Something just happened in the Epstein Files case that could be far more important than it initially appears. A federal judge ordered the Department of Justice to hand over specific unredacted Epstein-related documents for his private review. The DOJ did. The judge examined them, and then he issued another order saying the government's response did not comply with his previous order. Now, on August 13th, the Justice Department will be back in court. And this time, the question isn't simply, will the DOJ release the documents? The judge already has them. The question is, why wasn't the government's explanation good enough? Independent journalist and attorney Katie Phang filed a federal lawsuit against Todd Blanche in his official capacity as acting attorney general, challenging the government's handling of records covered by the Epstein Files Transparency Act. The dispute centers on a basic but critical question: which information can legally be redacted, and which information must be disclosed? The law allows certain information to remain protected, including identifying information involving victims. But the government has made specific redactions in the Epstein records, and Phang challenged aspects of those decisions in federal court. That put the issue directly in front of U.S. District Judge Emmett G. Sullivan. And that's where this story takes a very interesting turn. On July 25th, Judge Sullivan issued a short but significant order. He directed the Justice Department to provide specific Epstein-related documents to the court unredacted. But he wanted more than the documents. He wanted the government's supporting documentation for certain redactions. Think about what that means. If the government says this name was redacted because this person is a victim, the judge wanted the supporting material behind that assertion. If the government says this name belongs to a law enforcement officer, again, the judge wanted documentation supporting that claim, and the judge ordered the material for what's called an in-camera review. That's simply a legal term, meaning the judge examines the material privately. The public doesn't see the unredacted documents. The judge does. And that distinction is extremely important, because the judge isn't simply relying on a description of what's behind the blacked-out sections. He's looking at the underlying material himself. Judge Sullivan gave the government a deadline, July 30th at 3 p.m. And here's the first important fact. The DOJ did deliver the requested material by that deadline. The documents were placed in the judge's hands. Now Judge Sullivan could compare the government's explanations with the actual underlying records. And that changes everything, because up until this point, we're largely talking about competing claims. The government says certain information was properly redacted. The plaintiff says some of those redactions are improper. But now the judge has the material himself. He can look behind the redactions. He can examine the government's explanations. And he can decide whether they hold up. And then came the development that really gets my attention. On August 6th, Judge Sullivan issued another order. The judge said the government's response did not comply with his previous order. Why? Because the court had required supporting documentation for certain assertions, and the judge concluded that the government had not provided what his order required. Now let's be extremely careful here. This does not mean Judge Sullivan has ruled that Todd Blanche lied. It does not mean the DOJ has been found guilty of contempt. And it does not mean the judge has determined that every disputed redaction is illegal. That's not what the order says. What it does mean is this: the judge wasn't satisfied with the government's response. And when a federal judge tells the government that its response doesn't comply with a court order, that's something worth paying attention to. Here's the legal issue at the heart of this. The Epstein Files Transparency Act requires broad disclosure of responsive government records, but it does not mean every single piece of information must automatically be made public. There are legitimate reasons for protecting certain information. Most importantly, victims have a right to privacy and protection from further exposure. So the question isn't, should everything be dumped onto the internet? The real question is, are the redactions legally justified? That's what makes Judge Sullivan's review so important, because there is a major difference between saying, "We redacted this because the person is a victim," and providing the court with documentation that actually supports that conclusion. Judge Sullivan is now in a position to examine that distinction himself, and that could have consequences for how the remaining records are handled. Another issue involves FBI interview material. Investigators sometimes create handwritten notes during interviews, which can later be used to prepare formal interview reports. The court has been dealing with questions about whether certain underlying handwritten material should also be produced, subject to appropriate protections. The government has raised concerns about the difficulty of protecting victim information within those materials. But again, Judge Sullivan did not simply accept the explanation and move on. He ordered specific material and supporting information. And that's the recurring theme here. The court wants evidence behind the government's assertions, not speculation, not political arguments, documentation. Now here's where we need to be disciplined. There are enormous amounts of speculation surrounding the Epstein files, but the fact that someone's name appears in a document does not prove that person committed a crime. A redacted name does not automatically mean the person is a perpetrator, and Judge Sullivan's scrutiny does not mean he has already concluded that the government is hiding criminal conduct. We don't know that. What we do know is that the judge is examining whether the government's handling of these records complies with federal law and with his court orders. And right now, that's enough, because the next major development is already on the calendar. Judge Sullivan has scheduled a status hearing for August 13th at 1 p.m. And this is where the story could take another turn. The government will have an opportunity to address the court's concerns. The judge can ask why the required documentation wasn't provided. He can determine whether additional material needs to be produced. And depending on what happens, the court could issue further orders. But we should not get ahead of ourselves. We don't know whether there will be sanctions. We don't know whether additional records will be ordered released. And we don't know what the judge ultimately will conclude about the disputed redactions. What we do know is that the judge has already reviewed material the public cannot see, and he has already determined that the government's response was insufficient to satisfy his previous order. So here's what I'm watching. Not rumors, not internet speculation. The court record, because on August 13th, the government has to go back before Judge Sullivan and address these issues. And the most important question may be very simple. What happens when the judge asks, "Where is the documentation I ordered?" The DOJ has already put the requested records in the judge's hands. He's had an opportunity to examine them. And now, the court says the government's response didn't comply with what was ordered. That doesn't prove wrongdoing, but it does mean the judge is demanding answers. And if you're following the Epstein Files story, August 13th is the date to watch, because we may finally learn what Judge Sullivan wants the government to do next, and whether this case moves closer to broader disclosure. Until then, remember, let the evidence speak, let the court speak, and let's see what happens next. Justice matters.